My name is George Knott. I'm with the law firm of Knott, Consoer, Ebelini, Hart, and Swett. And with me today I have my partner, Tom Hart. Tom is a board-certified real estate attorney who focuses his practice in the area of homeowners association law. Seated directly to my left is, and let me go on, Tom is a University of Florida graduate, a Gator for those of you who are right. Seated next to me is Natalie Torres-Alvarado. Natalie is a lawyer that works with me in the area of commercial litigation. She's a graduate of George Washington University. Before she went to law school, she worked for the United States State Department in the Cuban interest section, and then went to law school at University of Florida. My topic today is directors and officers liability. And as everyone is aware, the title to this seminar is your association at risk? I'm going to modify the title of my lecture because my lecture should be titled, Are You at Risk? Because under Florida law, any officer or director of a common interest real estate entity owes a fiduciary duty to their association and also to the members of that association. This fiduciary duty arises primarily under three statutes, 718, which we are all familiar with, Chapter 607, which is a for-profit, the for-profit corporation statute, and 617, which is the not-for-profit statute. Now, what is a fiduciary duty? A fiduciary duty is the duty to act or give advice for the benefit of another. That it is your duty to provide advice for the benefit of other individuals. What are some examples of where someone breaches their fiduciary duty? We have self-dealing, when you're dealing for your own account and not for the account of your association. Usurpation of a business opportunity of the association. Ignoring conflicts of interest which exist between yourself and the association. Failure to disclose in the performance of your duty all known facts, and failure to act in a loyal manner to the association. Well, we know what the wrongdoing is. Who has standing, who has the right to go down to the courthouse and file a suit against an officer or a director? Members of the association or the association itself. Now, in the late 1980s, and I am old enough to remember the late 1980s, in the late 1980s we had an insurance crisis in the state of Florida, and basically insurance companies ceased writing directors and officers liability insurance because it was just not a good line of business to write because the claims exceeded the dollars they were bringing in. And this caused a problem in Florida because without D&O insurance, volunteers tend not to want to serve as officers and directors because they're exposing their personal assets and are not protected or insured against any claims that might be filed against them. So what did the Florida legislature do? The Florida legislature fixed this problem by creating statutory immunities. Okay, and these statutory immunities were created both under the For-Profit Corporation Act and the Not-for-Profit Corporation Act. And why they created these statutory immunities was to make it more difficult to recover against an officer or a director. The statutory immunities set forth in Chapter 617 state that you can only be held liable as an officer or director if you breach or fail to perform your duties as an officer or director, and that breach is a violation of criminal law, B, a transaction or other where an officer or director acquires an improper benefit like a payoff, or where you act recklessly or in bad faith. If the conduct that is complained of by the aggrieved member or the association does not fall into one of those categories, you cannot be held liable. So the Florida legislature, to encourage people to serve as officers and directors, has narrowed down, has tried to shut that window of liability on claimants, but it still exists. What other defenses are available to you as directors or officers in the event of a claim? Well, Florida has codified what has been referred to as the business judgment rule. And under Florida law, the business judgment rule is a rule which basically, in its simplest form, stands for the proposition that if you exercise good business judgment, you cannot be held liable for any actions you take. In other words, you can't act arbitrarily, capriciously. You have to act in good faith. You have to consider the information that is presented to you, and you have to make informed decisions. And so long as you act in that manner, then the business judgment rule is available as a defense should someone assert a claim against you. Under the statute, and this is a plug for my profession, so I'm going to give it, and also for any community association managers and CPAs, insurance representatives, property managers. If you are on a board of directors, or if you are an officer and you rely upon the advice of someone who professes to be knowledgeable and that you know to be knowledgeable in a particular area, and that advice turns out to be wrong and someone is harmed, you are statutorily deemed to be protected by the business judgment rule. That doesn't mean someone can't sue you, but you are afforded that protection. What right do you have, but let's assume that you get sued, what right do you have to be reimbursed by your association for the cost that you incur in defending yourself, having to go out and hire a lawyer or whatever expense you incur? What right do you have under the law to be reimbursed for that? Well, if ultimately there's an adjudication in your favor, you have the association has an obligation to reimburse you for your attorney's fees and for reasonable costs. That's if there's an adjudication in your favor. Even if there's not an adjudication in your favor during the pendency of the claim, it is within the discretion of your association to reimburse you for the cost of defense that you incur. Now, how do you protect yourself? What are some of the high points or takeaways that we would like to learn today that would protect us with respect to the specter of directors or officers' claim? First of all, rely on your professionals. Your employees of the association, your community association manager, your attorney, your accountant, your insurance professionals, and document it. Document the advice they give you in the minutes that are maintained for your association, and that will provide you with some protection. Now, if the window of liability has been narrowed so much, why, George, do we need directors and officers liability insurance? If the Florida legislature has created immunities and you're telling us that if we rely on our professionals, we're fine, why do we need D&O insurance? Well, I like to say that you remember the old adage, sometimes the cure is worse than the sickness. That has a lot of applicability to a director's and officer's claim, because many times the real expense that you incur in these claims is not the the judgment or the final decision which might be rendered against you in the claims, it's the cost of defending yourself. To have to go out and hire an attorney to defend against the claim, to struggle through this process. Well, insurance companies have two obligations. The first obligation they have is to indemnify you. If you have a contract of insurance and there's a loss experience that is covered within the four corners of that insurance policy, the insurance company has to pay that loss on your behalf. But more importantly and more broadly under Florida law, the insurance company has a duty to defend you, to hire an attorney to provide you with a legal defense through trial. And many times, as I indicated, that can be much worse than the ultimate outcome of any claim.